Welcome aspirants. Today we will discuss in this approach to law optional our next topic, that is principles of natural justice and emerging trends and judicial approach. So before I begin, why this topic is relevant for all of you? This is the question every aspirant should ask to themselves. Because in the paper, unless and until you understand the pattern, you won't be able to prepare your notes in that light, in that context, and you won't be able to add the concrete material. Because in UPSC, as I always mention you have to be very unique with respect to your answer writings, with respect to your answers. So how this unique approach of writing the answers you should inculcate in yourself, that I'm going to discuss with you. So in this particular topic, that is about principles of natural justice, all of you have heard about this word a lot of times. So what it is all about and why this topic is relevant, what is the context? Because in this approach to law optional, at GS Core, we are making you aware how to, figure out from the previous year questions and from the current context, the expected questions in the forthcoming examination. So that is the main approach which we are following right now. So in this approach, first we will discuss PYQ, then I will discuss with you the current context in which this topic is more relevant, and then what kind of expected questions you can figure out in the forthcoming examination, mains examination. So that is the approach right now we are following here. Last year we have seen this question, explain the significance of odi alteram partem and what are the cases or circumstances in which the aforesaid principle of natural justice can be excluded. As you know very well that in case of principles of natural justice, we have been given three major principles. One is, you know very well, this nemo judex in causa sua, then odi alteram partem, and the reasoned decisions. These are the three main principles of, you can say, the principle of natural justice. And last year, this question was specifically about the second one, that is odi alteram partem, which means the other person, the person at other side, should be given a fair chance of representation, so he can defend himself. So it is about, you can say, hearing rule. Now coming to the main idea, what is the current, the idea in which we are perceiving that this question might come this time as well. So to understand this point, the current context in which this question is relevant for all of you, this is more evident from the recent ruling of the Supreme Court in SBI versus Rajesh Agarwal and others. This judgment came on 17th of March 2023. And this question, this particular case was mainly about the adhering to the principles of natural justice in the administrative domain. So what actually happened in this case? In 2016, few guidelines were made by RBI, Reserve Bank of India, with respect to classification and reporting of you can say, the fraudulent transactions or the borrowers who are committing fraud. So basically, these guidelines or directions were known as Master Directions on Frauds. Master Direction on Frauds. 2016. In these directions, what banks were doing, banks at their own end, they were simply checking out the profiling of the customers, and they were checking out who are the defaulters and who can be categorized as a fraud. So without giving a chance to the borrowers, the persons who have borrowed money from the banks, So without giving any chance to the borrowers, banks were classifying the customers as a fraud at their own, without giving any show cause notice why you should be classified as a fraud or why you should be classified as a defaulter. So without giving these kind of, the opportunities of being heard, banks were classifying the customers, and this was actually impacting their CIBIL score, you can say credit score. And because of this rating, they weren't been able to get loans from other bankers, even not from the other non-banking financial institutions as well. Because this particular, under this framework, borrowers were simply labeled as a fraud, as a fraudster, simply. So they challenged, many of the borrowers actually, they challenged that this particular direction at the end of RBI is in, you can say, serious violation of principles of natural justice, because they are not giving a opportunity to hear us. There might be several reasons, and this has become one of the main contention of the day, whereby businessmen are simply labeled as like just कि ये तो fraudsters हैं या सुनते ही नहीं है basically. We are not, we are not hearing to the businessmen. This is the biggest issue. People are simply labeling the businessman as a chore. And this is the, growing tendency which is ultimately going to impact our economy. And this tendency should be stopped. Anyhow, this is not concerned with the topic, but this is also one of the serious issue whereby businessman is being portrayed in a negative sense. Civil matters are becoming criminal matters. This is a very serious concern for the government, and this should be taken at priority. But anyhow, we will just focus upon our topic right now. So if you look at this current context, you can check out that in this particular case, Supreme Court held that these guidelines are in violation of the principles of natural justice, and the borrower should be given a chance of representation so they can justify why they have defaulted in their payment and why they are not being labeled as these fraudsters or defaulters. So this was the outcome of this judgment. In the light of this context, once again, the question is about the violation of the principles of natural justice in administrative scenario. So if you look at this particular point, you can simply figure out what kind of questions you can see. So by looking at the PYQs, by the previous year questions, along with the current context, you can simply figure out what kind of probable questions you can see in the next mains exam. So I will take directly to you to the expected question. I'm just showing you right now, and I will come back to the concept and then the answer writing. So like, for example, this kind of question has been given over here, that the line of distinction between the quasi-judicial power and the administrative power is getting obliterated and discussed with reference to decided cases, number one. And now X, a senior officer of Y, gave adverse remarks in the confidential report of Y, because of which Y could not be promoted. X was the member of the departmental promotion committee, in which Y appeared for the interview. Y wants to challenge the decision of the committee on account of bias, advise Y, and explain through judicial decisions about the application of the principles of bias. So this question, I have just given this question as a hint that these kind of questions you can see in the mains examination this year as well. Now coming back to the concept. So if any question pertaining to principles of natural justice comes before you, whether of 10 markers, 15 marks or 20 marks, what we can do, first of all, you should prepare your model answers of 20 marks question. And then you can, if you prepare your complete answer from 20 marks perspective, you can, come out of as a 10 marker question or 15 marker question as well. So this is the approach you should follow, number one. And another main point, if you look at this probable question, you can check out that right now recusal of judges is happening at a very high level in our country. Recusal of judges. Like recently, there were few cases in which Justice Shah was challenged. He was told to recuse from a case, but he denied. Similarly, same thing happened with our CJI right now. So the point is whether a judge who is anyhow not directly or indirectly connected, but if you say that this particular judge or particular judicial authority is having some kind of biasness factor, so whether the judges or those adjudicating officers should recuse themselves or not, That is the question. Because for that purpose, first of all, you have to understand what is the concept of principles of natural justice. So, first you should start explaining, first every one of you should start explaining what is principles of natural justice. What is principles of natural justice? So, first you should explain this. Okay. And after this, we will focus upon, so what do you mean by principles of natural justice, how it originated? So you start this from the relationship of this with the natural law school, whereby all human beings are termed equal because they are being made by the divine power. And if we are being made by same divine power, we all are equal. And because of this equality, every human being should be treated in a genuine manner. So to give a fair treatment to the human beings, they should have some basic, basic kind of protection. So this is basically principles of natural justice, whereby every person, every human being on this earth should be treated in a genuine manner. For that purpose, principles of natural justice, of course, it gives you three main maxims, or three main, you can say, the divisions of this P and J, which we talk basically this nemo jurisdiction causes हुआ, Audi alterum partum, and then reasoned decisions. So if the question is 10 marker question, explain these points in 2 lines. If it is a 15 marker question, then extend with an example. And if it is a 20 marker question, highlight the other elements of these maxims as well. Okay. So when we talk about this, it simply means no one can be a judge in its own case. So the recusal of judges is somehow concerned with this point only. And what you can do, you can just, note down one very interesting case over here. This is AK Karaipak versus Union of India case. So AK Karaipak case versus Union of India 1970 case, which is a very interesting case, which is all about, you can say, because when we talk about the nemo judex in causa sua, we are talking about rule against bias. We are talking about rule against bias. Because there are certain things which we can consider in case of biasness. Because if the same person is, is the judge, and that same person is also an accused or a party of the case, or somehow any kind of relationship with other party, so that is obviously going the, having the adverse impact upon the other party. And when we talk about the biasness, you can see personal biasness, pecuniary biasness, where the monetary relations are there. Personal means when some relationship, personal or familiar or some friendly relations are there. Subject matter biasness, we do have departmental biasness. Okay, when the same department is having the quasi judicial forum as well as administrative authority, so this kind of biasness we see generally. Along with this, we can see basically this preconceived notions biasness as well, when a particular judge is having the preconceived notions against any particular party. Because all of us are human beings, even the judges are also human beings. So sometimes we may be impacted by this kind of biasness. So to remove this biasness, so we should ensure that the parties and the adjudicating authority, they should not have any kind of relationship with each other. And that is the reason we generally talk about the recusal of judges. So in such a case, you can record this AK Karipak case. This is one of the interesting case whereby this person was himself, you can say, the acting chief conservation of forest officer, and he was also in the list of the the panel of UPSC as well. So he was participating in this interview process, and he was also a candidate for this post for the chief conservative officer. Okay. So when his selection was happening, when he was giving the interview, obviously he was not in the panel, but he was at the other side. But the point is, when he was participating in the interview process of the other interviews or the other candidates, then obviously he was getting the idea like what kind of questions are being asked and how he can prepare himself. So it was held in this particular case by the Supreme Court that it is a clear-cut violation of this rule against bias, because that person is having, you can say, full knowledge of internal working of this panel, and ultimately this kind of selection should not be a genuine one, because it is just in violation of principles of natural justice and more specifically rule against bias. So you can quote these kind of the cases, landmark cases you can quote over here. So if a question is 20 marker question, you can stretch it out. You can quote the facts as well, you can quote the judgment, the crux as well. But if it is a 10 marker or 15 marker question, only mention the case and the crux. No need of mentioning the facts. So by this strategy, you are preparing at the same time, you are preparing different kind of questions, the answers of the different level of questions. Okay. So this case, the judgment you should mention over here, and you can mention the different type of biasnesses over here. Okay, so you can deal with this, and in our probable question, you have to just focus upon this main point. First, you will discuss P and J. Okay, then you will discuss about these three maxims, and then you focus upon this particular case, and you will mention about the different type of biasnesses, and then you will decide that it is in this probable question, it is obviously case of, you can say, biasness. Okay. Then you have to mention odi alteram partem. The other party should be given a chance of fair hearing so that he can represent himself, whereby you can say notice should be given to the other party, then he should be given the chance to present his case, he should be given a chance to give the evidences, he should be given a cross examination, you can say the chance of cross examination the opposite party and their witnesses, then he has the power to rebut the other party's evidences. Similarly, he should be, when there is an inquiry report, then he should be given this inquiry report as well, and then post decisional hearings as well. So these are the main elements of this particular point you should mention in your answer when you are writing this concept. And then reasoned decisions, or you can say speaking orders. And you know very well what is this all about? It is all about the concept of that whenever any judgment is being given by the adjudicating authorities or by any judicial authority, they should give the reason behind their judgment, because judgment should have the element of application of the mind, and you should give the reason why you are pronouncing this particular judgment. So you have to just mention these, you just focus upon the concept and try to learn how to write down the answers. So when you are writing the answer, you should be specifically focusing upon the hierarchy. So first explain principles of natural justice in just 2 or 3 lines at the max. Then the different 3 maxims of this particular P and J. And the question is about any specific maxim, then focus upon that only. So you first explain that these 3 maxims are a part of P and J, and then if question is about any specific point, like in probable question, it is about nemo judex causa sua, while in the last year question, it is about odi alteram partem. So you have to give a brief idea about these 3 maxims, and then you have to focus upon the main question and the relevant maxim. And then you have to quote the elements of this maxim. The elements, like in case of biasness, all those personal, pecuniary, subject matter, preconceived notion, those factors of the maxim, and then the landmark judgment. And if you are aware about any present scenario, so like for example, in case of biasness, you can start with this recusal of judges. Or you can do one thing, you can mention this point at your conclusion part as well. Like in our judiciary, there is no specific law with respect to this recusal, but due to, because we know very well justice is just not to be done, it is just, shown to be done actually. Dikhna bhi chahiye. So in case of recusal of judges, you can just relate this in the introduction part, or you can use this in the conclusion part. That to maintain this dignity of this post, this profession, this position, they recuse themselves. There is no set criteria, there is no set, you can say, specific provision, but they do this to maintain this integrity, dignity of this post. And this actually happens in our judiciary. So ultimately, we can see, and you can rate all these points over here. Okay, and if you remember any kind of present situation, please try to mention that present situation or present kind of, you can say, the issue in your answer writing. Because if you do so, it gives weightage to your answer. Because what we have seen, many of the aspirants, they forgot to mention these current things. Please relate your answer with the present scenario or present issue or any current context in which you are talking this answer, you're writing this answer. Okay, so please focus upon this kind of answer writing approach, and ultimately you will be getting lot of, you can say, like because you are, when you are tackling the mindset of the paper checker, this is going to give you the edge as compared with the other aspirants. So if you write in this way, believe me, you are obviously going to be an UPSC, as the worthy UPSC aspirant, and obviously a civil officer. So that's all from my side today. Thank you all. Thank you very much. All the very best.